Hi, everyone, and welcome to the Adams and Reese AR/HR Summit. My name is Kellen Mathews. I'm the partner in charge in our Baton Rouge office, and today I'm joined by my colleague Hunter Schoen from here in the New Orleans office. We're here to talk to you today about workplace drug testing in the age of legal marijuana and how to avoid half-baked policies. Before we get started, though, we have a couple of housekeeping notes. We want to hear from you today, so if you have any questions, you can drop those in the question box in your control panel, and we'll see those. And then, to the extent that we can get to some of those today, we will. But we will also follow up offline after the session with those of you who we don't get to. Also, near the end of the presentation, you'll see a badge on your screen, and you can download your continuing education credit at that time. Now, in past years, when we're in person doing these, I would now say it's a look under your seat that we have something to make the presentation more enjoyable. Obviously, as we're about to get into, the landscape of what you can and can't do across various states is kind of dicey. So we don't have that, but we promise to make this an enjoyable program and hopefully informative as well. So with that, let's get started. So here's a little roadmap. We're going to cover a fair amount of landscape in this 30-minute presentation. First, we want to touch on and take a look at the drug laws and policies that serve as the backdrop for employment-based drug testing with respect to marijuana specifically. And then we'll look at the current status quo of federal drug testing, kind of the nuts and bolts of what you can and can't do under current law. Then we will dive into some of the ways that courts have treated medical marijuana in the workplace here recently. Then we'll take a look at some of the legislation, or take a look at generally the landscape of where marijuana is legal and in various forms it's legal. And then we'll look at some of the legislation that's been passed or pending. And we'll look at bans on pre-employment marijuana screening that some municipalities and even employers have implemented on a broader scale. And then finally, while the landscape is very hazy, we're going to try to give you some kind of tools to navigate the ever-changing landscape of marijuana use and how it interacts with the workplace. So first we'll start off, as some people say, you got to know where you've been to kind of know where you're going. So we'll look at federal drug policy in the past and present, see how we got here and kind of why we are where we are. Kind of a linchpin for this, and the Controlled Substance Act is the law that establishes federal U.S. drug policy. There are 5 schedules of controlled substance under the CSA. You've probably heard of these, and if you're familiar exactly which ones are where. Marijuana is in Schedule 1. The Schedules 1 through 5 are based on the potential for abuse of the drug, whether it has an accepted medical use or not, and then finally, whether it's the level of safety and the potential for addiction. Under the CSA, as I mentioned, marijuana is Schedule 1. Other drugs in that same schedule include heroin, MDMA, which you may call Molly, and then LSD. So very different drugs if you look at it that way. How did marijuana get looped in with these other drugs? Well, the answer there is more political than any kind of science. This CSA came about during the Nixon administration. It was pushed by the Attorney General at the time, John Mitchell, and as I mentioned, it has more of a basis in politics than it does actual science, because even a commission that was set up by the Nixon administration to kind of study how marijuana should be handled under federal law found that it should be more of a medical, public health approach than a prohibition approach, as what was ultimately enacted. So other laws that kind of come to bear is federal criminal law, obviously, that the use and possession of marijuana is a crime. And then there's the ADA that kind of touches on employees engaging in illegal drug use is not qualified under the ADA. And employers are, generally speaking, not required under federal law to accommodate legal drug use, but as Hunter touched on with respect to medical marijuana, there's a little nuance there that's come out of some of the cases that we've seen. In addition to the laws that are on the books, there's federal drug policy, which is generally set by whatever administration is in office. And so in the last, I guess, 10 years or so, We've had a change from in the Obama administration. There was the policy that was articulated in a memo called the Cole memo that kind of said we're going to take a hands-off approach where states have chosen to legalize use, and they have robust protections and regulations in place. We're not necessarily going to step in and kind of do federal drug law enforcement in those states, provided there's no broader reason for us to do so. With the change of administration in 2018, Attorney General Sessions rescinded that memo and shifted back the marijuana drug enforcement policy for the feds, and said that it was a return to the rule of law and that they will enforce. It was a very broad statement that they'll use well-established principles when pursuing prosecutions related to marijuana activity. So, kind of roll back the more lax nature of that Cole memo. And then most recently, with the new Attorney General, new administration in office, Attorney General Garland has not said really one way or the other whether he plans to reinstate the policies from the Obama administration from the Cole memo, but in his confirmation hearing, it seems to suggest that he would take an approach that has less of a focus on federal prosecutions of some of these issues. And so we look a little bit at the kind of progression of public sentiment, because as you can imagine, public sentiment has shifted a lot in the past 50 years. You see, back in 1972, it was around the time of the beginning of the CSA, Americans, by and large, almost 90%, thought that marijuana should be illegal in any form or fashion. And contrast that now, today, closer to 70% think it should be legal, at least in some form. And then now, like I mentioned, we've got a drastic shift in the policy. You have only less than 10% of those surveyed in the April 2021 poll thought that marijuana should not be illegal at all. Compare that with the overwhelming majority that we saw last in the early 70s. And you mentioned on the other side of this slide, it shows that majorities across all age groups, with the exception of those over 75, feel that marijuana should be legal, and that's important to note because our president is over 75, so that might drive some of the policy from the White House. Recently, there's been legislation just trying to reconsider some of how we treat and deal with marijuana at the federal level. Legislation called the MORE Act was introduced last year. It made its way through the House, but ultimately did not pass through the Senate. It was reintroduced again here in May, and that's still pending. And then recently, just a couple of weeks ago, the Senate also introduced legislation it's quite similar to the MORE Act, but it's obviously in the Senate. It's called the Cannabis Administration Opportunity Act. It would decriminalize and deschedule cannabis, as we talked about in the CSA, and it would provide for reinvestment in certain persons and areas that were impacted by the war on drugs, and would also provide for expungement of certain cannabis offenses for certain people. As mentioned, not yet to be seen kind of how the White House is going to come out on this, so stay tuned. And now I'm going to turn it over to Hunter. He's going to tell you a little bit about the current status quo of how drug testing works in the workplace.
Thank you, Kellen. So when looking at drug testing under federal law, it's important to look at mandatory zero tolerance policies, because now seeing the states that are moving towards legalization either in the medical or recreational context, before that, most employers never thought twice about their marijuana policies or drug policies in their handbook. And so now that it might be legal in some states in certain contexts, it's important to think to consider when can you drug test an employee, or should I have a mandatory zero tolerance policy? Generally, there are not a whole lot of instances where you're required to have a mandatory zero tolerance policy. That said, the Federal Drug-Free Workplace Act does require you to have one, and that applies to federal contractors. Notably, the act does not require or prohibit drug testing, but requires certain things, the certifications and the maintenance of a drug-free workplace. There's also certain branches of the government or commissions or departments that require drug-free, have certain positions or generally be drug-free. Those include the Department of Defense, Department of Transportation, and Nuclear Regulatory Commission. There's also an instance where if you receive a federal grant, you may be subject to the Federal Drug-Free Workplace Act. Now, looking at drug testing generally, when can you drug test an employee? There's 4 instances. Pre-employment. Now, the requirement of pre-employment drug testing is that it be tied to a conditional offer of employment. So that means you can't just drug test every applicant that applies. Now, if you decide you want to offer that person, but that offer is contingent on a drug test, that's okay. Reasonable suspicion. This means if this is a current employee in the workplace and you reasonably believe that that person's on drugs, you can, or impaired by or under the influence of any type of substance or drug, that you can drug test them. Important here, though, the reasonable suspicion must be objective and as it says in this name, reasonable. Later in the presentation, we'll talk about some factors when considering reasonable suspicion, specifically as it relates to marijuana use. The third is random. For a random drug testing policy, the policy will not violate law so long as each time you institute a drug test via the random policy, that every employee has the equal chance of being selected each and every time. Post-accident drug testing. Now here, there's some OSHA regulations that define what you can and can't do for post-accident drug testing. For it to be lawful, there must be a reasonable basis that the drug use contributed to the injury or illness, and the drug test will help determine whether impairment existed at the time of the accident. There's also other general requirements under federal law for drug testing, one being the medical review officer must review the drug test. This is where you don't just go to CVS and buy something off the shelf and drug test your employees. Often, as you may already know, that employers are using third-party vendors to conduct their drug testing, and a lot of times these requirements we're going through that they already have in place because they're well-versed in the law and whatnot, and so that can be helpful if you're new to this field. Positive drug test results must undergo confirmatory testing. Again, your third-party vendor will usually have a policy in place for that. Employees must be provided the opportunity to provide medical information that may impact test results. I guess an example of where this may come into play is if an employee tests positive on drug tests but has a prescription for that substance and the employer is not aware of it, they must be given an opportunity to explain or give information that would justify the positive test result. And just so as in every situation where you're dealing with protected health information of an employee, must be kept confidential, all their information in that process. Now that we've kind of discussed drug testing generally in federal law, let's look at medical marijuana and in the case law and how courts have treated it. We're seeing this change over the last 5 to 6 years because historically, as you know, and as Kellen mentioned, courts and the law generally was very employer friendly when it came to decisions or adverse actions taken against employees for use of medical or recreational marijuana. Now, one of the big shifts we saw occurred in 2017, and it happened in Rhode Island in the Callahan versus Darlington Fabrics case. There was an applicant that disclosed to her employer in the application process that she was a medical marijuana card user due to Crohn's disease. And then she advised, look, I'm not going to be able to pass the pre-employment drug test, but that she wouldn't bring marijuana to work. Her future supervisor at the time told her, don't worry, that's okay. And then actually a week later after that conversation, they called her back and said, hey, look, ran at the chain. This is fine. Don't worry about it. Nonetheless, Callahan took the drug tests and on her first day of work was fired. Or sorry, I'm mixing up two cases. The company refused to hire her even before conducting the drug test. The important fact there was that the employer's policy only prohibited use of drugs on company property, and it did not tie the offer to the drug test. So in light of that, the court found that this violated the anti-discrimination statute in Rhode Island, and the plaintiff was actually granted summary judgment in this case pretty quickly. The major points here is that the medical marijuana statute created an implied right of action. It also said that employers may not refuse to hire an individual due to his or her status as a medical marijuana cardholder. And then there was also, you'll see consistently in the case laws that there's no conflict between the CSA and the state's law allowing medical marijuana use. Now, Barbuto, the next big case that when you're dealing with medical marijuana in the workplace. Here, as I mentioned erroneously last time, this had to do with the employee applying who had Crohn's disease and let her supervisor know. As I mentioned already, the supervisor called, said not a problem, and then also told her again that this is not an issue. Well, of course, she takes the drug test and is fired because of a positive test result. The court then found, because that this medical marijuana was tied to an underlying medical condition, that the adverse action taken against her was in violation of Rhode Island state law because the employer did not engage in the interactive process. So the big thing from here is that you must engage in the interactive process. Kellen?
Yep. So now I'm going to hip you to the legalized marijuana scene as it exists currently. And as of this morning I woke up, I checked, 36 states have some form of medical marijuana, as well as DC and 4 U.S. territories. So it's widely throughout the United States. As you can see from the map, the actually justifications for these various colors are kind of small, so I'll go through them. You see a lot of green, and the various shades of green correlate to various statuses of legalization. Gray is a completely no-fly zone. It's illegal there. The lightest green you see is where marijuana has been decriminalized, and typically what that means is that there's no arrest or no prison time and no criminal record for the first-time possession of a small amount of marijuana for personal use. And then the slightly darker green, those states have medical marijuana use only. And then the even darker green, slightly darker green, they have medical and decriminalized marijuana. The darkest green, you know the vibes, legalized marijuana. And we see those states, we see the 27 states have decriminalized marijuana possession, including Nebraska and North Carolina, which have neither recreational or medicinal use on the books. So we'll take a look now and look and see what some of the state legislatures have done in our footprint, which is, generally speaking, the kind of Gulf South SEC region. And we'll look first at Louisiana. Louisiana passed HB 652, and the governor signed it into law. It just went into effect, and it decriminalized possession of up to 14 grams of marijuana. So it takes off the table possible jail time, and it maximizes the penalty at a fine of $100. This is not completely novel because there were already ordinances on the books in some of Louisiana's more major cities, in New Orleans, Baton Rouge, and Shreveport, all had some sort of decriminalization on the books. This just kind of brings everybody into line with that. Alabama, they passed and the governor signed a medical marijuana bill. So that made Alabama the 36th state with a full medical marijuana law. Hate to give them credit for anything, but there you have it. Texas, they expanded. They had already had a low THC medical cannabis program, and now it includes people with cancer and PTSD. This was largely spearheaded by veterans groups who had kind of advocated for, particularly with the PTSD issue, for some sort of increase in the program, which was extremely limited and remains relatively limited, but it's been expanded some, and so the trend is going in that way. That goes into effect on September 1st. So now we'll look at some of the near misses, the legislation that was proposed but did not pass. One of the biggest ones, the Louisiana considered potentially legalization of recreational use for adults. That bill ultimately did not pass. It was largely the part of it that did not pass, and it kind of hung up the whole thing, was the taxing mechanism for what would be this new industry. That was not able to, they were not able to work that out, and so the legislation failed. Since it is a fiscal issue, it's only brought up on odd years, and not odd as in 2020 odd as in even odd numbers. So we're looking at another 2 years before this will come up again. Fully anticipate that it will come up. The Sheriff's Association, they were against the bill, but also in their opposition still conceded that it's very possible that we're soon going to see legalization of recreational use in Louisiana. Alabama considered a decriminalization bill. That ultimately did not pass or did not get brought up for a vote. So they did not have that. Then three other states in our footprint, Tennessee, South Carolina, and Georgia, they're among the 14 holdouts who still have no form of a true medical marijuana law. They considered such laws in their sessions and ultimately did not pass any of these. So as you can see, there's a lot of legislative activity. A lot of the states are looking at and reconsidering these. So the momentum is there to where it will be more widely seen throughout our footprint, throughout the United States as a whole. And that brings us to our next thing is, in addition to the legislation that we're seeing put about, there is also city ordinances that are changing what employers can do as far as pre-employment marijuana screening. First one we'll look at is in New York City. They have passed a law that prevents certain employers from testing job candidates for marijuana or THC as a condition of employment. Similar thing in Philadelphia, they prohibit employers from requiring employees to submit to testing for the presence of marijuana in the employee system. That goes into effect at the beginning of next year. And then kind of outside of that vein of big urban areas, you've got a southern city, Richmond, Virginia, that has asked to amend its administrative regulations for the city to exclude marijuana from the substance abuse detection program that it has. And this is really for city employees at this time, so that's somewhat more limited than some of these other things we're seeing. And then California, which they were kind of on the cutting edge of all this legalization talk way back when. They've had medical marijuana on the books for the better part of 25 years. They considered a law that would prohibit employers for taking action against an employee based on a positive marijuana test, with some exceptions, of course, for safety-sensitive positions. That ultimately did not pass the legislature, so that's not on the books, but imagine that will keep coming up. And then next we look at what some of the bigger employers have done. Amazon, the second largest employer in the country, in June, they announced that it would no longer include marijuana in its comprehensive drug screening program for any positions that aren't regulated by the DOT, so safety-sensitive positions like delivery truck drivers and forklift operators. They don't come under this, so they would still potentially get tested in pre-employment screening. And Amazon's, the way it's treating it is they're going to treat marijuana kind of the same as alcohol use and presumably opiate use as well. And they're going to do more impairment checks on the job and will test for these use for everybody only after an accident in times or where there's reasonable suspicion. And it's something that we're going to talk about. I mean, it's something that other employers may also consider going to that, even though they don't have necessarily the legal implications in their state, just because, as we're talking about with COVID and as we move beyond COVID, hopefully, some employers, particularly in the service industry, are finding it hard to keep fully staffed, and particularly some employers are having to make the choice to whether I want to have a zero tolerance marijuana policy or cover my third shift because I don't have enough employees and eligible people that can pass a drug test. Brief note here, Amazon's shift in its policy, was not just this kind of change of mind they had on their own. They were actually sued by a New York employee who the recreational use was legal in his jurisdiction, was not so elsewhere, and he filed suit. They ultimately resolved that. But this is the kind of outcropping of that. And that also brings up another issue that you see kind of in the COVID and post-COVID kind of is the workplace shifts. You have employees that may work in different places, different jurisdictions than where the company is situated. So you also have to be sensitive to what laws apply in the jurisdiction where an employee actually sits. So it's just great to have a broad view of everything that's out there. And now we're going to talk a little bit about how to navigate the hazy, pun very much intended, landscape of drug testing, and marijuana testing in particular.
Yeah, so best practices for employers. So the reason why you're here, what can you do and what should you do? First, I think it's important to note that when you're looking at your current policies, whenever your state's considering legal medical marijuana or recreational marijuana, This does not require a huge change in your policies. You don't need to go have an addendum made where you have 5 pages of single-spaced policy for what to and not to do. Largely what you're going to be doing is looking at your current policies and do I need to tweak them one way or the other to address the issues that may come up with medical and recreational marijuana. As Kellen mentioned, you're seeing a lot of employers treat legal marijuana the same way they treat alcohol and opiates and other type of substances that may cause impairment. But when you're looking at what can you do within your handbook, one good place to start is looking at how you define the employee's role. Like we mentioned in the Darlington case, the handbook at the time did not prohibit legal use of medical marijuana at the workplace. So one thing you can do is make sure your employee handbook does prohibit the legal use, not just illegal use, but legal use too. Identify what an employee must do if he or she is prescribed medications that carry a warning label or may cause impairment. Again, your handbook may already address this, but be sure to note that this extends to legal marijuana. And also require that employees in the safety-sensitive positions disclose use of a lawfully prescribed or recommended drug which may impact the employee's ability to perform his or her job before reporting to work. One thing to note here is that your handbook should identify which positions are considered quote-unquote safety-sensitive. A lot of times you see that with employees operating heavy machinery, and sometimes the prescriptions or the warning labels actually will list what exactly it extends to. So for example, you're on a construction site, somebody's operating machinery, they're on prescription, whatever it may be, marijuana or something else that could affect their ability to do that safely, then that is something you should address in your handbook. But not everybody has that currently, and so with marijuana coming into place and the fact that it can impair an employee at times, you should definitely include that in your handbook. Next, it's list prohibited substances and corrective actions. Again, clarify which substances are prohibited, and like Kellen mentioned, that we're seeing this extended to opioids when not prescribed, because that's been one of the trends in the workplace over the last 10 years. Reserve the right to send employees in safety positions to a fitness for duty evaluation, and update list of essential job functions for each job description to include the ability to work in a constant state of alertness and in a safe manner. Now, your job description may already include the safe manner, but where we see a lot of gaps in handbooks and descriptions is the essential job functions does not include constant state of alertness. Now, you might be thinking to yourself, that's almost presumed. You need to include it. It's better safe than sorry. Also, you want to detail the disciplinary consequences for refusing to submit to a drug test and for testing positive on a drug test. Similar to any type of discipline procedure or policy you have in place, this should be something that has a little nuance to it and gives you some flexibility. It's not just automatic termination, but also instances where you can take other types of actions. One thing to keep in mind here too is use versus impairment. What is your policy trying to prohibit? One thing you see in the case law or the courts are reluctant to enforce policies that seek to regulate conduct at home, especially when you're talking about lawful substances, and that might extend to recreational marijuana. Also, it's important to consider when you're looking at your disciplinary consequences and things of that nature is what's the context of the positive test result. We talked earlier about the 4 instances where you can drug test an employee, being pre-employment, random, the post-accident, and also reasonable suspicion. And so the justifications for taking certain action will be different in certain situations. If it's random and there's no evidence of impairment, only just use, do you take the same action as if it's impairment on the job that resulted in a post-accident? Now, obviously, it requires a little nuance and it's an employer's decision, but whenever you're treating it the same way as alcohol, sometimes people are not automatically terminating employees due to a positive test result based upon the circumstances. Next, earlier we talked about reasonable suspicion. This is important because you can train your employees to look out for it. And so whenever you're deciding to drug test an employee in the workplace based upon reasonable suspicion, you need to be able to document it and justify it based upon things that can be linked to marijuana use. Now, this is important because not all symptoms or side effects can be related to marijuana use. An example of symptoms are short-term memory loss, loss of balance, trouble hearing or seeing, increased drowsiness, fatigue, and lethargy, and other instances listed here on the slide. And to contrast this, here are some symptoms of impairment due to opioid abuse. Obviously, if you're going to test somebody in the workplace and they test positive for marijuana and you're saying that there was reasonable suspicion, you don't want to list side effects or symptoms that would be, I guess, attributed to another drug or something else. And as you can see, it's such extreme mood swings, increased drowsiness, fatigue, and lethargy. Another important thing to keep in mind is, and as you're probably very well aware of, and it's probably been mentioned at all these presentations, is document, document, document. You want to document everything. Make sure they read your drug-free workplace or drug testing policies. Again, not all employers have a drug-free workplace policy, but whatever your policies specific are to drugs, have a specific acknowledgement assigned to that so everybody's on the same page. And sometimes, obviously, there's instances where you're not sure if the employee is reading it, but if you have the signed acknowledgement, the onus is not on you, it's on them at that point. Perform written job performance evaluations regularly. When doing that, if you update your job descriptions to include things as alertness and other things that may be related to identify medical or any type of marijuana use, have those type of evaluations included in there. Keep a record of on-job incidents and conduct a thorough investigation. That's obvious and it's probably not new. Document any signs and symptoms and keep an employee's personnel records. Also, keep a record of supporting disciplinary actions and recommendations. Again, you want to be able to justify your actions, and this is where we're seeing the shift from use versus impairment and making sure you're taking actions to regulate conduct in the workplace, not just legal conduct outside the workplace. Okay, so you have an employee test positive. What next? As we saw in Barbuto, you want to engage in the interactive process. One big distinction here is, are they a medical marijuana user or are they using recreational marijuana, legal or illegal? If it's not medical marijuana and it's not tied to underlying medical condition, then the very first question, the process may end there because there is no underlying health condition where you have to consider it can be related to. But for example, if it is tied to underlying medical marijuana, a medical condition, then you need to determine whether the user could not be hired or remain in that particular position due to undue hardship or safety risk. Also, you want to look at accommodations before getting to the undue hardship and the public safety risk. You want to look at accommodations such as, is there an alternative method for this person or alternative treatment that is equal treatment that does not involve the use of medical marijuana. Now we see sometimes where people provide FMLA or discretionary leave to the employee in the instance where they may have to use marijuana due to a medical condition and cannot then report to work because of potential impairment. So what does this mean for employers? Kellen's going to wrap us up with this.
Thanks, Connor. So obviously, the biggest thing, with shifting landscape, ever-changing laws, stay informed of your employment obligations relative to medical marijuana use, and keep your drug policies up to date. I mean, the laws are ever-changing, so you need to be aware of what's out there to avoid becoming the next test case. And take precautions when using a positive medical marijuana test to make an adverse employment action against a qualifying patient, sort of what Hunter just went through. And then consistency. That's the case with any policy, particularly in the case of the drug policies. You need to train supervisors so they know what to look for and then apply your policies consistently throughout. We're going to I have a couple questions here that have come in, and we'll take a look at those. First one is, so if my state legalizes recreational use of marijuana, does it still make any sense for me to test for marijuana in my drug testing panel? I want to make this very clear that despite the complicated status of marijuana in the workplace and drug testing we've talked about, employers are under no obligation to accept intoxication in their workplace. So always able to test for intoxication. So it makes sense even once, if medical, or not medical, but medical and recreational use is accepted in a lot more states, still makes sense to look at doing reasonable suspicion testing if it fits with your workplace, particularly in instances where you have safety sensitive positions. So it's going to make sense to Whether it makes sense to have a zero tolerance policy more globally, that's up to each employer. You have to kind of look at your situation, as I kind of alluded to, particularly in the service industry, and particularly with the difficulty in finding employees right now. It may be worth examining how strict you are with respect to use that's not actually impairing the individual and putting the safety of your workplace in jeopardy. So that's that question. There was one more. We have time for one more question, and any of those other ones that would come through during the presentation, as I mentioned, we will take a look and cover those offline. We'll get with you as we can. This one says, my employee tested positive for THC and blames the use of CBD oil. Can I discipline an employee based on this test? First, CBD oil should not trigger a positive test. The amounts of THC in it are so low that it would take an extreme amount in high usage, in which case you might be looking at a potential impairment situation if someone was to submit a positive test based solely on CBD oil use. But that said, as Hunter mentioned earlier, you should have a process in place that includes a reliable checks and balances system, including a medical review officer and an opportunity for the person to submit justification for their positive test. Now, if you go through all of that and the positive test remains, then yes, you're by all means able to take action based on that, provided that your policies prohibit that sort of thing. And that's our time here. We again thank you for joining us for this presentation. We hope that we've helped you with some items that you can take to help navigate the haze of the marijuana testing in the workplace as it stands today. We hope that you will enjoy some of the rest of our programming. And with that, we'll see you later.